Welcome back, everyone, to Open Line. Glad you are with us. We are talking with elder law attorney Chris Johnson, joining us via Zoom from his office there in Hendersonville, Takacs McGinnis, and talking about planning. I think in this segment, I want to talk. What should we talk about? Like, what did you say? Irrevocable trusts? Is that right?
Irrevocable trusts, the advanced planning. So we talked about in the last segment kind of the foundational documents of what is needed in everyone's estate plan. When you're 18 and you've become an adult, you want that legal decision making in your durable general power of attorney. You want a healthcare power of attorney because you want to make sure that people can make those decisions, and it's not naturally vested in anyone. Just because someone's your parent doesn't mean they have that legal authority once you're an adult. Just because someone's your spouse, it doesn't mean they have that legal authority inherently. You need to execute those documents. So we talked about those foundational documents. Then the next thing is people will often ask about asset protection. Chris, what do I do? When is the right time? And I always say, first off, the right time is now. You get in with an expert who can walk you through what's appropriate. And then what you do is security. That's when people are looking for asset protection, really boiled down to its most nebulous form. They're looking for security. They're looking for financial security. They're looking for personal care security. They're looking to make sure that they feel safe about the future. And so what you want to do, like any type of security you do, you want to layer it. You want to have different things that are all working together. And so I mentioned at the beginning of this, when you get into your mid-40s, early 50s, you want to look at a long-term care insurance policy. It's not the right fit for everyone. We don't sell insurance at our firm, but we certainly recommend it because we see lots of clients who come in who are very concerned about the costs, and then out comes this long-term care insurance policy, and we review it for them and we tell them what it means, and you can just see the look of relief on their face. Someone 20 or 30 years ago made a very good decision, made a very wise investment, and now they are very much less concerned about the cost of care, given some of the policies where it can truly take the care cost worries absolutely away, or at least mitigate them. Then once you start getting into retirement age, we need to look at, okay, we have a home, typically people's largest asset. What are the things that we can do with that home? Should we place it in an irrevocable trust and have that protected, shielded by that trust? And what happens is the mom and dad can still live at the home. They can still have the use and enjoyment of the home. But what they've done is they've effectively given legal title away, given legal title to the trust. And then what happens is at their passing, the same thing that would have happened had they just left it in a will or left it in a revocable trust, it'll eventually pass to the children, but they retain that right of use and occupancy. And what it's going to do is it's going to make sure they don't lose the home to estate recovery, and they don't lose the family farm or another piece of property that has deep meaning to the family. Then you're looking at the liquid assets. What do we want to do? I always say I want to keep liquid assets in the control of my clients for as long as possible because they worked hard. We're talking about their nest egg. And that's probably the biggest concern of every elder client that comes in, is saying, Chris, I don't want to lose control. And there's always, I tell them every time, there's going to be a balance. There's a balance between a little bit of loss of control and making sure that your assets are protected. Because when you protect the assets, what you're really trying to do, it's never that they're not going to pay a dime for their care. And I tell every client that, like, you're going to pay for your care. There's going to be some money that you're going to pay out of pocket. What I want to make sure is that you don't have to pay every last dollar. It's kind of like going to your tax preparer. You don't ask your tax preparer and say, well, I don't want to take any deductions. I want to pay the most taxes possible. I don't care if there's a deduction or not. I don't want to take it. Well, the law, as far as qualifying for TINCREAR, qualifying for VA benefits, like anything else, there are effective paths to get there and there are ineffective paths to get there. And what you want to do is apply those rules and make sure you're getting there in an efficient manner so that you have some assets reserved, A, so that you have that cushion should anything bad happen, you have some money to fall back on, and B, what is very important to a lot of our clients, and it surprises me, just the generosity of parents, how selfless parents are. They're worried about their own care costs, and they'll say, Chris, I know I'm worried about this, but I want to make sure there's something there for my son, for my daughter, for our kids. We want to make sure that we're able to leave them something so they're better off after our passing. And so all of these things work together. And so you look at, maybe we set up their will in a way that we can protect some assets, set up the home in the irrevocable trust. And what we're trying to do is make sure that they can pay for and find good, effective care that keep them keep them healthy and keep them safe in their environment, because staying safe makes you healthy, and staying healthy keeps your quality of life high. And that's what we want for our seniors. We want them to have as good a quality of life as possible.
Boy, that covered a lot. That's a great answer. And this, to drill down into that answer, you said you don't want people to lose their house or the family farm. And so how would you lose the house and the family farm? And again, I guess go over, how do you prevent that from happening? Why would that happen? Why would you lose the house or the family farm?
Yeah, so TennCare is a government program, and like any other government program, it requires funds, and funds are finite. They're finite in the government. They're finite in our personal family budgets. I'm sure they're finite at NewsChannel 5. There's, we have money to do X and Y. Maybe we don't have money for Z. And so the government kind of found this balancing act where they said individuals can qualify for TennCare without having to sell their homes. And I think that's a good thing. We don't want to force mom and dad to sell their homes and liquidate every last thing they own before they qualify. But what happens is you qualify for TennCare, but after their passing, what TennCare is going to ask is that because the home is left in the estate, that they have that money returned for them dollar for dollar by having that home sold. And that's a mechanism called estate recovery. But the problem is there's lots of reasons why you would put a home in a trust. There's other things you protect besides from TennCare. So what TennCare says is, listen, putting a home in a trust is absolutely fine. There's a million reasons to do it. If you do it within 5 years of needing skilled nursing care and needing TennCare's assistance, the presumption we're going to have is that you did it purposely to qualify and shield the asset, and they will penalize you for that. But if you do it outside that 5-year parameter, and that's where thinking ahead and really planning ahead really matters a great deal. I get asked all the time, Chris, do people really plan more than 5 years ahead? Absolutely. The wise ones do. They come in and they say, what are these things we need to do? You place the home in the irrevocable trust, and now estate recovery cannot claw back that home. And what you've done is you've made a very wise estate planning choice.
Wow, I like that. That's great. All right, I want to talk about wills. I'm always fascinated by wills and just the battle over wills. Do you see some tough battles or not? Hopefully you all obviously write wills but do you see people that want to come in and overturn wills? How tough is it to overturn a will? Do you see these kind of battles? What about that?
We tend not to see them in our practice. The clients that come to us oftentimes are kind of one big happy family. Everyone's working together, as you alluded to at the beginning, where the children reach out and just trying to help mom and dad, or mom and dad come in and say, listen, we want to make sure the kids are taken care of and we don't leave them a hot mess when we pass away. And so our practice lends itself towards that scenario. But people do try and contest wills from time to time. The first thing I would tell everyone is it's tough. It is a long shot. You really have two prongs, legal approaches to challenging a will. The first would be that the testator, the person whose will it is, lacked the capacity to sign the will. Basically, they signed a document and had no idea what they're signing. And if you can prove that, you might be able to effectively contest the will. The other angle of attack that you can have is something called undue influence or duress, where essentially maybe a caregiver, who's been there, gets them to sign a new will and give them an outsized portion, and the children's shares are cut way down because they've used their influence. They have unduly used their influence to try and push that individual into a certain decision that they wouldn't otherwise have made. So those are really the two approaches to attacking them. The bar to a successful will challenge is very, very high. Demonstrating that someone lacks capacity, you're going to need, letters from doctors who had evaluated them at the time they were signing the will, that say, hey, and layperson testimony saying they had no idea what was going on. Remember, a will is going to have to be witnessed by two individuals who are unbiased. I like to say, who don't have a dog in the fight, which means they're not beneficiaries in the will, they're not family members, they're just two. So we use our staff to witness our wills, and those witnesses are going to testify, and they swear on an affidavit. We watched this person sign the will, they understood what they were signing, and so that inoculates most wills against that type of challenge. The last piece to make it even harder to challenge a will is something called an in terrorem clause, which literally means to terrorize. And basically, it's a clause in the will that says if anyone brings a lawful, a challenge against this will and tries and challenge any section or the entirety of the document, you are going to lose whatever inheritance is there in the will. Usually effective over.
So they threaten them with that. That's
so
interesting.
That's right. If you're a child who's getting a greatly reduced share and you're like, this is not my fair share, and you think about challenging and you see, well, if I challenge and fail with this in terrorem clause, now I'm going to be completely out. It's a real big dissuader from someone bringing that challenge.
Very interesting. And I feel like there was a period where there were several celebrities that were dying and didn't have wills. And again, a will is another one of these gifts that you give your family. Obviously, you're not around, but it helps prevent bickering and just makes things so much better. So it's a gift again, right? I mean, when some of these celebrities died, chaos ensues, and you just don't want that.
No, and that there's almost no excuse for that when you have the resources that they do to have all this planning in place, because they know they're going to be a target. It's a large estate, and there are people who are up to no good in our society, unfortunately, who are going to try and weasel their way in and try and see if they can get something out of it. And if you don't have your ducks in a row, and if you don't have all your documents put together right, and have someone, or maybe even more than one person, who knows what your plan is, knows where the important documents are, and can get things kicked off right out of the gate when you pass. It is making sure that those people know what to do upon your passing, so you don't leave the chaos, because that chaos inevitably leads to litigation. Litigation is exceedingly expensive, and all that is going to do is going to draw down the resources of the estate and the resources of the people who should have been lawful heirs, and you might have wanted them to be heirs in your will, but you didn't finish getting all these documents done. Now they're spending money out of their own money trying to get what you wanted them to have in the first place. So it is a nightmare when you don't do that.
Wow, that's interesting. All right, we'll take a break. Come back. Continue our discussion right after this.